Hello viewers, I am Dr. Wajda Rahman. Today we will discuss marriages among Muslims under the law relating to Muslim marriage. The main objective of this module are to know about what marriage is under Muslim law, to know about the impact of marriage on Muslim society, to know about the nature of Muslim marriage. Let's introduce the topic. As the oldest and purest institution on earth, marriage is defined as the fitting together of two individuals. Every religion has a distinct goal for marriage. Hinduism, for instance, views marriage as a dharma, yet marriage is required by many religions for a variety of reasons. Muslims see marriage as a contract, but it is not a pure contract, whereas Hindus view marriage as a holy institution. Islamic marriage rituals don't include a long list of intricate traditions and rituals. The Sharia does not outline any particular series of steps or ceremonies that must be performed in order to join in this arrangement, despite its religious importance. The most important and necessary ritual that has to be performed is the Nikah ceremony. In pre-Islamic Arabia, marriage was a simple process. Muslim or Muhammadan laws is not codified, in contrast to Hindu law. This causes havoc and uncertainty about the validity of several marriage-related rights and issues such as consent, age, divorce, maintenance, custody, etc. The Parliament enacted some laws to address the numerous issues that resulted from Muslim law not being codified. In this lecture, we will talk about the characteristics and prerequisites of a Muslim marriage. Aim and objective of Muslim marriage under the religion. Muslim law states that being married should only happen when one has a thorough comprehension of all the rights and duties that Allah has decreed, as well as the wisdom that underlines this institution. There are two primary goals of Muslim marriage. One, procreation. For Muslims, having children is the primary goal of marriage. They tie a knot in order to preserve their family line and make a positive impact on society. While it is possible to accomplish this goal without being married, doing so is seen as disobedience to Allah, and those who do so feel that they will not be blessed by Allah. 2. Pleasure. Muslims believe that a man's and the woman's desire for one another is a natural instinct that must be gratified. They even acknowledge the desire that exists between man and woman. Additionally, the Prophet, peace be upon him, says that this desire is normal and should not be repressed or rejected. Thus, they see this enjoyment as the secondary goal of Muslim matrimony. Classifications of marriage. Broadly, Muslim marriages are of four kinds: valid marriage, sahi; void marriage, batil; irregular marriage, fasid; temporary marriage, muta or nikah, muta. Let's first discuss valid marriage, sahi. A marriage is valid or sahi when all legal conditions are met and there are no restrictions that impact the participants. Both temporary and permanent bans are possible. If the prohibitions are temporary, the marriage will be deemed irregular. And if the prohibitions are permanent, the marriage will be invalidated. Let's discuss about the effects of a valid Muslim marriage. It becomes legal for the husband and wife to live together. Children born into lawful marriages are entitled to inherit their parents' possessions since they are legitimate. There are established reciprocal rights to inheritance for husband and wife. In other words, upon the husband's passing, the wife is entitled to inherit his belongings, and the husband may also inherit the wife's belongings after her passing. A forbidden connection is formed between a husband and wife for marriage purposes, and it is against the law for either of them to marry someone in the other's relationship to the extent that it is prohibited. The marriage must adhere to Islamic law, which mandates that certain phrases to be spoken, witnesses be present, and the bride gets her fair share of the dower, that is meher. As soon as the marriage is over, the wife's entitlement to dower is established. The wife's right to immediate support from her husband is conferred upon her by marriage. Following the breakdown of the marriage, the widow or divorced woman is required to mark the next 3 or 4 to her or menstrual cycles as the iddat period, during which she is not permitted to remarry. Void marriage, batil. Any marriage that violates the laws of affinity, fosterage or blood tie is null and invalid. Likewise, it is null and invalid to marry someone else's wife or a divorced woman during the iddat period. Due to the marriage's invalid ab initio status, the offspring of such unions are illegitimate and have no rights or duties. In the case of Munshi versus Alam Bibi, that is 1912 case, the court noted that a marriage is considered invalid where there is a permanent or continuous restriction from being married owing to non-compliance with a condition. In the case of Tanjila Bibi versus Bajrul Sheikh, that is 1986 case, the court determined that a marriage is considered invalid if the woman was already pregnant before the marriage. Irregular marriage, fasid. A marriage may become irregular because of a failure to follow certain requirements or the presence of a fixable obstacle. Yet, this irregularity is temporary and may be overcome. Therefore, the union is legal in and of itself. Once the restrictions are changed, it may be considered legitimate. In the case of Ata Muhammad versus Saikul Bibi, that is 1910 case, it was noted that if a marriage is temporarily outlawed but not definitively limited, it is considered to be irregular or fasid rather than invalid. An unconventional marriage has several facets and diverse perspectives. Marriage in such circumstances or with the following prohibitions is called fasid or irregular marriage. Number 1. A marriage arranged with fewer witnesses than necessary. Number 2. Union with a woman who is in her iddat phase. Number 3. A union with a woman without getting her guardian's approval when it's deemed essential. 4. A marriage that is forbidden due to religious differences. 5. A union with a pregnant woman if the pregnancy was not brought on by fornication or adultery. A union with a fifth wife. Temporary marriage, muta or nikah-e-muta. Pleasure marriage or delightful marriage is the literal meaning of the phrase muta. A muta marriage is a brief, mutually agreed upon arrangement that lasts just a short while. Shia schools sees it as a kind of short-term marriage for amusement or pleasure. When a marriage contract is signed, the duration of the union and the dower are set. The marriage is null and invalid if the duration of the union is set but the dower is not. This kind of marriage may be arranged by a Shia Muslim man who marries a lady who worships fire, a Christian, a Jew, or another Muslim. There is no set minimum or maximum duration. It might be 1 day, 1 month, 1 year, or more. The marriage dissolves on its own when the predetermined amount of time has passed. If no such time restriction was stated or documented, the marriage will be assumed to be eternal. This kind of marriage is common among Shia Muslims, while Sunnis disapprove of it. There is no denying the prevalence of muta marriage in our nation. Although certain people get into muta weddings, these unions are not legally binding in India and are thus not recognized. There is no distinction between a muta for life and a muta for an ambiguous time. In the current day, imams and other Islamic authorities often arrange temporary marriages or mutas between Muslims in the Middle East, Europe, and America. Nonetheless, the 12 Shia Act, which makes up 90% of the Shia population in India and is the major religion in Iran, regards it as valid. The habit of sometimes using the term muta is known as sigah in Iran. Now let's discuss polygamy. More misconceptions about Islam are spread by this topic than any other. While polygamy, or taking many spouses at the same time is legal in Islam. It is not advised. The old beliefs sanctioned unrestrained polygamy. Islam regulates the number of spouses that a person may have and bans having more than 4. It is said in the Holy Quran, however, if you think you might not be able to handle them fairly, then marry just one. Quran chapter 4 verse 14. Islam holds that having a mistress and committing adultery are serious crimes that lead to the moral decline of society. In some cases, polygamy is seen as required. Nonetheless, it can only be carried out under certain acceptable circumstances, and even then only with restrictions. Islam forbids polyandry, or a woman being married to more than one partner. Wives who feel their situation is untenable may apply for a divorce if their husbands are infertile, threadbare, and ill at the time. Now let's discuss about the nature of Muslim marriage. Muslim law refers to marriage as Nikah. The Arabic meaning of the word is union of two people. According to Bailey's Digest, Muslim marriage is a contract that permits sexual contact and childbirth. Nevertheless, Hidayah, a commentary or handbook on Islamic law, describes Nikah as a carnal union in its most basic form. The Prophet of Islam, peace be upon him, said that one of his sunnahs, that is the practices, is marriage, and his adherents are obligated to respect and adhere to his customs. One topic that often comes up when discussing the nature of Muslim marriage is whether it is a contract or a sacrament. While some legal scholars contend that Muslim marriage is a civil contract, others contend that it is a sacrament in and of itself. Therefore, 3 distinct aspects, legal, social, and religious, are taken into account while talking about the nature of Muslim marriage. Now, legal aspects of Muslim marriage. According to the legal perspective, marriage is a civil contract among Muslims since it has traits associated with contracts. These are the following: a proposal or ijab from one side and an acceptance or qabul from another side, or similar to the proposal of a contract. Free consent is a crucial component of a contract. In a similar vein, permission from both parties is required for a marriage to be consummated, and consent cannot be gained by deception, pressure, force, or other unfair means. When a minor reaches the age of majority, which is the same as puberty for Muslims, they have the choice to renounce a marriage that their guardians arrange for them. Another name for this puberty choice is Khair-ul-Bulugh. Likewise, a guardian may annul or control a contract he enters into on behalf of a child until he reaches adulthood. Any kind of antenuptial or postnuptial agreement between married spouses is permissible as long as it is legally enforceable. The only requirement is that it makes sense and does not conflict with their religious beliefs. The bride and groom may modify the conditions of the marriage as stated in the Nikahnama, provided that they stay within the bounds of the law. In Abdul Qadir versus Salima 1886 case, the ruling established that Muslim marriage is a contractual arrangement in that sense. Now, social aspects of Muslim marriage. Muslim marriages have goals, much like any other marriage. These are as listed in the following order. It mandates that household life continue, the birth of offspring, taking care of and being accountable for the wife and kids, the survival of the human race, achieving continence, tenderness, tranquility, purity, and mutual love. These goals suggest that Muslim marriages have a social component because of their interaction with society. According to Chief Justice Sulaiman in Anis Begum versus Muhammad, that is in 1933 case, Muslim marriage is more than just a legal contract, since it is based on the notion that two individuals are united by emotion, love, and the feeling of community. He countered that it is a religious right as well as a legal contract with social responsibilities. Now, religious aspects of Muslim marriage. A different perspective on Muslim marriage is that it is a religious sacrament rather than just a civil union. It is considered an ibadat by certain jurists, meaning a devotional act. According to the Prophet, peace be upon him, any Muslim who is competent and willing to assume the responsibilities of a wife and children must get married. There are several indications that this is more than just a contract. Unlike a civil contract, it is not contingent upon unforeseen circumstances. It is not done for a certain amount of time. However, muta marriages are an exception. Unlike in a civil contract, there is no such thing as a right of lien in a Muslim marriage. The wife receives the dower, which is regarded as a symbol of honor and deference rather than a financial benefit. Thus, it may be claimed that while marriage is seen as a holy bond in Islam, it is also a contract. The goal is to keep society free of immorality and filth. The erudite Islamic scholar and jurist Abdur Rahim provided a fair explanation of Muslim matrimony. He states that the custom of Muslim marriage is seen as a human transaction known as muamalat and as an act of devotion known as ibadat. Now, let's discuss the general and exceptional rules related to the religion as an essential part of Muslim marriage. The partners in a Muslim marriage must be Muslims in general, yet Shia and Sunnis have different laws. It is permissible for a Sunni man to wed a Kitabiya lady, but he cannot wed an idolatress or a fire worshipper. However, Shia men are prohibited from doing even that. Muslim women are not allowed to wed non-Muslims, otherwise the union would be deemed null and invalid. The different kinds of absolute prohibition in Muslim marriage. It is forbidden for a Muslim, regardless of gender, to be married to someone who is related to them by blood or in a band connection. There are outright bans. It is arising from consanguinity, that is qurabat. Blood ties such as a mother or a father, daughter or son, sister or brother, grandmother or grandfather, etc. are referred to be consanguinity, qurabat. Affinity, musharat. This term refers to intimate connections such as those with the wife's mother, the wife of her father, etc. Absolute bans forbid marriages between them. Fosterage, from the Arabic word for milk relationship, is known as reza. A woman becomes a foster mother when she breastfeeds or feeds a child under the age of 2 and is not the child's biological mother. In this partnership, marriage is also forbidden. The significance and importance of the iddat period. If a marriage ends in divorce or the husband passes away, a woman must follow the Islamic period of seclusion known as iddat. The purpose of monitoring this time frame is to determine if a woman is pregnant and to prevent misunderstandings about paternity. The iddat period's duration is calculated as follows. If the woman is pregnant, she must follow the iddat for 4 months and 10 days after the husband passes away or is divorced. If the woman has been menstruating for 3 lunar months, the iddat period is 3 months in the event of a divorce. The start of the term is the date of the husband's death or divorce. If an irregular marriage has not been consummated, no iddat is required to be kept. In the conclusion, marriage unites two individuals, but it also unites two distinct families. Due to the fact that Muslim marriages are seen as both a spiritual and a purely civil transaction, they are by their very nature pragmatic. The primary goal of Muslim weddings, as stated by Islamic law, is to legalize childbearing and sexual relations. In religious weddings, the presence of free consent, sound mind, and the assent of the majority of the parties determines the legality of the union. 4 situations in Muslim law renders a marriage null and void in specific situation involving Muslims. Islam prohibits women from entering into interfaith marriages but permits male to wed Kitabiya women. In Muslim marriages, a dower is required as a token of respect for the woman. Muslim women are only permitted to practice monogamy, whereas males are permitted to have up to 4 wives. The primary issue with Muslim law is that it is not codified, in contrast to other personal laws. This has resulted in many interpretations and practices, which have added to the turmoil and muddle. Certain of its actions were deemed unlawful because they violated basic rights. To eliminate doubt and promote clarity, Parliament passed several pieces of legislation. The courts of law must nevertheless resolve a certain amount of ambiguity, however, as and when it is presented to them. That's all for today's lecture. I hope you have enjoyed the lecture. Thank you very much.